Okay, so professors, going back to this case between the Republic of um, Western Australia versus Clark. Now, this is what happened. There was a murder. Okay, so two policemen were murdered, and Clark was first apprehended. Okay, why was he apprehended? Because the police felt that he was an accessory to the crime, as in he knew something about the crime, so he was a suspect. Okay, they were suspecting him to be um, an accessory to the murder of the police. In fact, there were two policemen. So when Clark was in custody, he didn't know that the government has offered that anybody who would provide information leading to the arrest of the true perpetrators of the crime, the person is going to receive, I think it was £1,000, okay, at the time. So Clark, because he wanted to clear himself that he was not a culprit and all that, gave the information that finally led to the arrest of the true murders of the policemen. So when Clark later came out, he saw the offer the government was giving to whoever was going to provide the information. So now he sued. That is why he went to claim. Sorry, he didn't sue. He went to claim the reward. So the country took the thing to the court to determine that Clark didn't have any basis to claim the reward. Okay, so it was the Republic that took Clark to court to settle the case because Clark was demanding or claiming for the reward. Okay, so if you look at what the court said, the court held that Clark could not claim the reward because his information was not provided in exchange for the reward offer. He had no intention to accept the offer at the time he provided the information. Now, let's discuss this and relate it to the consideration we are looking at. In this case, what was the consideration? The consideration on the part of Clark was to have provided the information. Okay. And the consideration on the part of the county was to give the reward of £1,000. Now, was it executory or executed? Let's discuss. Let me hear your views before I add my verdict. So to you, do you think the consideration in there was executed or executory? Or was that of the government executed or executory and that of Clark executed or executory? Let me hear my professors on this. Let me know what you are thinking now. Who should I call? Let me get to those who have not spoken today. The birthday boy is is in a serious contribution mood. Birthday boy, hold on your thoughts. I'll come to you. Let me see. Prof. Selikem, Lawyer Selikem or Judge Selikem?
So please, I'm still thinking about
You are
it.
still thinking, okay. Who has finished thinking about it? Okay, but do we all agree that consideration is the exchange, the valuable that is exchanged? So in this case, the consideration was providing the information, and the other consideration was giving the 1,000 reward. Okay, so that is the consideration. But I want to determine whether they are executory or executed, or whether one is executed and the other is executed. So let's hear. Portia wanted to say something. Posh, let's hear.
The piece is executed.
Okay, which of them, or is it the both of them, or a particular one?
A particular one, the government.
The government's consideration was to provide the reward, which is the £1,000, right? You consider that to be executed?
Yes.
Okay. That's Portia's view. Let's hear from other professors. Prof. Josephine, are you still thinking?
Please, I think the money they were supposed to give for the person to the person who gives the information is the executory. So that's for the government. And then the information he provided is executed.
Okay. Thank you. Let me hear from like
No.
two more professors, and then yeah, Portia, please, either you want to edit or update.
Yes, edit.
Uh-huh.
And third place is executory, because they said unless you provide the information before you get the reward. But Clark did that but forgot about the reward.
Okay. Okay. So yes, Prof. Selicum, let's hear you.
Sir, please, I have a question.
Mm-hmm.
Sir, please, they said the contract was not valid. So if a contract is not valid, can you still determine whether there was like a consideration executed or executory?
Okay. So great. Good question. Now, let me clarify the issues here. This case, okay, was not valid, not on the basis of consideration. Okay. Not on the basis that there was no consideration, but on the basis that Clark had not accepted or communicated any acceptance to the Republic. And I think I'll dig deeper into that. But for me, I wanted us to apply the concept of the executory and executed consideration. As we have learned, the executed consideration is one that is yet to be performed or given in a contract. Executory, because we say it is a future kind of exchange or a future consideration. And executed is one that has already been given or already been performed. So we want to digest this case to determine whether there was executory consideration or executed consideration. Please, do you get the point? I believe so. Okay, so in the court's ruling and judgment, yes, they admitted that there was consideration because Clark providing the information is something valuable to the country or to the republic, right? So that was considered a consideration. And since he had already performed that act, it was considered an executed consideration. Now, on the part of the government, as in the country, they offered to give the reward to whoever will provide the information. So at the time, theirs will be executory. It will be given at a future date, only when we have received the information. So it's futuristic. So the reward at the time the case was in court was executory consideration. So the court determined that. But the reason why Clark lost was because you were in prison. You didn't know that the government was offering this to whoever will provide the information. So the court ruled that Clark did not accept anything because you didn't even know the offer. You were not aware of the offer. Okay. So you didn't act based on the offer. He acted just to clear his name or to get out of prison or to get himself exonerated. But it was not to, as it were, take the opportunity of getting the reward. Because you didn't even know the offer. And you didn't tell the government that, oh, yes, I'll provide the information so that I'll take the money, because you were in prison and your main focus was to provide information so that your name can be cleared. So on that basis, the court ruled against Clark that he didn't have any valid contract with the Republic. Okay, so that is to say, if you do something for someone with a different intention, okay, I think Augustine has a question. Augustine, hold on. Let's say somebody's pen is missing, and then you didn't know that the person is offering, let's say, 50 cedis for whoever will return the pen. And then because probably they were suspecting that you stole the pen, you return the pen so that your name will be cleared. Now later, when you realize that, oh, the person was even offering 50 cedis, and you sue to go and claim it, well, on the basis of this case, you lose the case because you didn't act based on the offer. You did not even know that there was an offer of that nature. So that was the basis for the courts ruling the contract to be invalid. Okay, but we were looking at the executed and executory consideration that were in this case. Prof. Augustine Akoli, let me hear your question.
Say please, but my question is that the government also said that to offer a reward for the information. They did not specify that. They didn't specify. They just said that if you bring the information, we will reward you. So
okay, so this was a summarized version, but if you look at the details of the case, they put a price. I think it was £1,000. You can Google this case and read it and get the full details of the case later on. But I think they were offering £1,000 to whoever was going to provide the information. But the court ruled based on the fact that Clark was in prison at the time and had no clue the government was, So how do you accept something that you are not aware of? That was the basis the court used. And judge that he provided the information because he wanted to get out of prison or clear his name off the case. Well, the court is made up of human beings. You may agree with them or disagree with them, but in this case, that was what was ruled. And it is a precedence for further cases of this nature. Okay, so until another judge or another judge rules otherwise, this will be a guiding case for contract law as far as some issues of this nature are concerned. Okay, Augustine, you have another question? Go ahead.
Say please, I think this one, the court final say, I think it is bribed or is rigged. I also have an example. Say please, a bit like the one that the woman, the company this part.
The Miss Khalil versus the Carbolic Smoke Ball, yeah.
Yes, so please, yes. So let's say that, for example, according to that one, let's say that, for example, she didn't know that there was an offer like that, like they are advertising.
But hold on. In that case, the woman was aware because she saw the advert. Birthday boy, I know the angle with which you want to twist that case, but I'm not sure it will hold water because you see that case had a different or a unique feature from this one. That one, the woman watched the advert and saw the company advertising that if you buy the smoke ball and use it and you got influenza, they were going to give you the reward. So the woman was aware. But in this case, Clark was in prison. He didn't have any access to getting information about the reward. So it's weird for him to go and claim that, oh, I provided the information because I was aware. He wasn't. He provided the information at the time to clear his name of the case that he is an accessory to the murder.
Yes, please, but what I'm trying to say that let's for example, the woman did not know. Maybe she didn't have a television or radio. Maybe maybe she was not feeling well. Let's say and a friend introduced like the product to her. Like she has no idea. Yes. Then maybe she used it. When she used it, then she later find out that maybe they advertise that if you did not if you use it and still have the free, you still pay. Maybe, and so what about that one too?
So, well, like you are saying, so she didn't, you are giving a scenario where she didn't know about the advert. Then on that
Yes, sir.
basis, yes, the courts may have ruled or may rule against her, because if you didn't know the advert, but then another element will come in. The friend who recommended the drug to her, did she see the advert? So they would get to know the elements from the side of the friend too, okay, to establish that indeed. Because yes, I can see an advert and then come to my friend and tell him or her about it. If she goes on to use the drug as prescribed in the advert, yes, there can be a case, okay. But unfortunately for us,
Okay, sir.
that was not the nature of the case. So let's look at the case as it stood, okay. Mhm. Thank you for that question, though. Okay, so this is about this Republic versus Clark. Please, any further questions? Okay, then let's look at the third category of consideration, that is past consideration. Past consideration. Now, if we are not careful, we'll confuse ourselves with the executed and past. Now, past consideration is something that was provided, listen carefully, provided before the agreement was made. Generally, past consideration is not valid because it was not given in exchange for the promise. For instance, Ajua helps Yao move his furniture, and a week later, Yao promises to give Ajua 50 cedis for their help. Since Ajua's help was provided before Yao's promise, it is considered past consideration and is generally not enforceable. Okay, so why would the court even worry itself if the thing is not going to hold water? It is because cases of this nature would come where people would want to argue their case that yes, I did the thing before you even made the promise, but still you owe me that obligation. So the court defined this type of consideration that it is one that has been provided even before the contract was initiated. Okay, so let's say that you carry my bag to the dormitory today, and then tomorrow I say that, oh, for carrying my bag to the dormitory, I'll give you 50 cedis. The court says that since you performed that act, you took my bag to the dormitory before I brought in the offer for you to accept. It is considered past consideration. And for that matter, it is not enforceable in the law court. So such cases, if you take it to they will throw it away on the basis of the fact, or on the basis that it is a past consideration. So so please be mindful when you are entering into agreement with people and you have already done the thing before the agreement. Be careful, because you can suffer a loss because of this past consideration. I think there is a case there. So it says the case was between the Mr. Ardell. Oh, sorry, Mrs. Ardell. Okay, some names are very so it says Mrs. McArdle made improvement to a house, and after the work was done, the beneficiaries of the house signed a document promising to pay her for the improvement. The payment was never made, and Mrs. McArdle sought to enforce the promise. What did the court say? The court said that the promise to pay was not enforceable because the consideration, that is the home improvement, was past consideration. It was provided before the promise was made. And past consideration in law is not valid or is not enforceable. Okay, I think you understand this case very well. Unless you have any confusion, you can bring it up and then we'll sort it out. Any confusion on this case? Okay, so the fact here is that, for our understanding, the fact here is that if somebody performs an act before a promise was made, the person cannot enforce for the promise to be fulfilled. So if you polish my shoe and then later I come and tell you, oh, I'll give you 20 cedis for polishing my shoe, you cannot sue me. Or if you do, you will lose, because the court will rule that you did the act before I brought in the offer. It sounds weird and funny, and confusing. Why? Law is something. Yes, Augustine is confused here again. Lawyer Augustine, let's hear you.
So for example, like a scenario, like you come and cook for me.
Mm-hmm.
Then after cooking, then I'll come back later. Then come and say that, I'll pay for a service. You have already done it for me.
Uh-huh.
So like for all the time, so like something like this, I can use what you have said like for court, because even though that I've already done it, like why do like mama, like how do I put it?
Birthday boy, you are only expressing dissatisfaction with the judgment of the court. But the issue is, the court says that if you do something and the person makes a promise after you have done the particular act, you cannot enforce it because it's considered past consideration. So it means that consideration should either be executory or executed. Then you may have a case. But if it's past, okay, if it's past, so the difference between let me get this from my professors. What is the difference between the past and the executed? Maybe I have to share a bundle here to get my professors to talk. But based on what we have discussed, what is the difference between the executed and the past consideration? I would be happy if all of you would express your view on that. But again, Augustine and the rest of you, you can Google out the names of the cases so that you can get the details. Sometimes when you get the details of the case, you would understand why the court, ruled either against or in favor of. Okay, but because we are learning, we only quote a section of the case to make us appreciate the concepts that we are learning. Okay, but I want to know the difference between executed and past. Oh, my professors don't do that too. When you do that, it means I feel like I didn't teach anything, or you didn't understand anything. Yes, Selikim.
Please, for executed consideration, it is done in exchange for like the promise, and in past it is done before the promise. So like the past is not enforceable and the executed is enforceable. And we
Okay,
can also say the past like a form of appreciation for what someone has done. So maybe if you do something for me, out of gratitude, I'll say I'll give you something or I'll not give you something. So it's not enforceable.
okay, okay, okay. So if I were to mark this over 5, I would have given you 3 over 5. Emmanuel Kujo, let me hear from Emmanuel Kujo. Birthday boy, relax. Prof Ima or Judge Ima, let's hear you.
Say please, for the executed, it is when both parties uh, hold their end of the bargain for a certain reward.
Mm-hmm.
But for the past, it is like was like so like for the past it's like a promise that is
Okay.
made before an agreement.
Okay. I would have given you 2.5/5. It's because you are omitting a particular word or statement. Let me hear more thoughts from what they are saying is correct too, but just salt, a little pinch of salt missing. My namesake, Amwa. Today, who hasn't spoken? Now has spoken, Augustine. I think all of you. Prof. Janelle, and then Prof. Caleb. I haven't heard Caleb's voice. And Bridget, Prof. Bridget. Let me hear from these professors. I'll be so glad or elated. Yes, Prof. Janelle.
So please execute consideration is when something has already been done or given. And the past consideration is when something was done before a promise.
Okay. Okay. 2.5/5. Prof. Caleb and Bridget, would you share your thoughts or you are still jotting down points? Okay, their silence means they are jotting down points. So, professors, yes, the difference is the fact that for the executed, whoever gave such a consideration was aware of the promise or the offer. In other words, the executed consideration comes when the promise has already been made. But the past, it is done when the promise was not even in existence. That is the key difference. So we can say that the executed is post-promise or post-agreement. That is after the agreement. But then the past is before the promise or agreement. Okay. So executed consideration is when both parties are aware that, okay, so if you polish my shoe, I'll give you 10 cedis. Then indeed you polish the shoe. It becomes executed because you were aware of the promise that you'll get the 50 cedis. But the past, you were not aware the person was going to give you the 50 cedis. So then you went ahead to polish, which means you acted not expecting anything. So why then do you now come to enforce something that you didn't expect in the first place? So I hope you get the difference between the two now. So the past is done when the promise or the agreement was not in motion, but the executed is done when the agreement or promise or offer was in motion. Okay, thank you very much, professors, for your thoughts. I really appreciate it. I love law because sometimes if you compare law to common sense, you might think that law is not sweet, but it's very sweet. There was another case, Rose Collar versus Thomas. Okay, I think you can Google this out and read the full case. Okay, so professors, these are the types of consideration that we've looked at. Executory, executed, and past. But know that the past consideration is not enforceable in law. Okay, great. Another element we have to look at is the capacity to contract. In this life or in this world, it's not just anybody who can enter into a contract. You need to have the contractual capacity. That is also another interesting element of contract, and there are a lot of cases in there. Sometimes you marvel why the court, ruled or argued in certain forms. But if you look at the details of the case, you would appreciate why the judge or the court ruled in such manner. So what is capacity to a contract? Contractual capacity is the legal ability of a person, which in contract could be an individual or corporation. Okay, so it's your ability, your legal ability to enter into a binding agreement. So what it means is that by law, are you sound to enter into that agreement? That is capacity to a contract. Now, parties are free to enter into any contract they desire unless they lack the capacity to do so. So there are some contracts, if you don't have capacity to do so, you shouldn't enter, because at the end of the day, if you suffer any loss and you sue, you may not get anything. The law prohibits certain individuals from entering into contracts. These persons include, and I'll call them minors, minor, M-I-N-O-R, minor, and Moframba, children, minors. Individuals under the age of 18. In this country, we know that if you are not age 18, you are a minor, right? Okay. Now, minors are not capable of entering into a contract. However, if they enter into a contract of necessities, in fact, this thing is interesting, and I need to take my time so that professors will understand. So we are saying that a child who is under the below, look at even the English I'm saying because of the enthusiasm of this element. A child who is below age 18 is a minor. And per the laws of this country, you don't have the capacity to enter into a contract. But there are exceptions. One of the exceptions is necessities. So as an exception, minors are allowed to enter into contract for necessities. What are necessities? Necessities are defined as, things or conditions that will help the child, or that will benefit the child, or would improve the welfare and interest of the child. So we have things like books, clothing, food, and shelter. And there's one case which is very interesting. Some small boy be entered into a contract with, I think, some hotel company that he went there and booked a room. And later, when it was time for him to pay, he said he was a child. But then the court ruled that the hotel services gave him some shelter, which is a necessity. As a matter of fact, shelter is considered one of the basic needs of human beings. So he was made to pay, and at that point, the parents had to come and pay. Okay, so if you enter, even though you are a child, if you enter into some contract and there are some necessities in there, for example, you go to a wachi seller, you take wachi, and you don't pay, and you say, "Oh, I'm a child, forgive me," the court will rule against you, because even though you're a child, that food, you needed that food to survive, and it's a necessity. Okay. Now, there's a case here. It says Nash versus Inman. I think that is it says Nash, a seamstress, entered into a contract with Inman, Elena, and Minor to sew 8 waistcoats. Inman later refused to pay, and Nash sued him. The court judgment. The court ruled that the waistcoats were luxuries, not necessities, and therefore the contract was void and unenforceable. If the waistcoat had been limited to 1 or 2, the court might have enforced the contract, as it would have constituted necessity, for which Inman had the contractual capacity to enter into. So you see, well, the fashion designer or the seamstress was not smart. Why would you give a child how many? 8 waistcoats for what? So the court ruled that, well, it is a clothing, but it looks like it's a luxury. This is not a necessity. Waistcoats 8 or the other. Now, other people who don't have, or other entities that don't have contractual capacity is intoxicated or drunk people. Please don't enter into any agreement with somebody who is drunk, because you lose your court case against the person, especially when you know at the time that the person was drunk. So those of you who have been doing contract or entering into contract at the beer bar or drinking bar, be careful. Third parties, but in this case, there are exceptions though. Third parties, persons who are not directly involved in the contract. Okay, again, you cannot deal with just anybody. For example, you have a contract with me. When you see, let's say my father, you'll be dealing with my father. Meanwhile, the contract is between you and myself. So third parties also don't have contractual capacity unless you have enough information that. Then we also have nationals of a country at war. or refugees. Let me put it that way. Then we have people that are declared bankrupt. Okay, so it says undischarged bankrupts, like the way GN Bank was shut down and declared bankrupt. If you have any contract with GN Bank, at the time they were declared bankrupt, you are just having a void contract. Individuals who are mentally incapacitated, it will be surprising for you to enter into a contract with, excuse my word, a mad person, somebody who is mentally not sound. Sometimes not just a mad person, but the person is not mentally sound. Okay. So Professor, these are the groups of people who don't have contractual capacity, minus drunk or intoxicated people, bankrupt, individuals or entities, people who are mentally unstable, right? How many? 1, 2, 3, 4. You can add nationals of a country at war. Imagine when Liberia, there was this war, and then somebody from Liberia runs into Ghana and says, "Oh, give me a place to stay. I'll pay you 100 Ghana cedis every month." If you agree such a contract, you know that you are doomed. If the person does not pay you and you sue,